Ladies and gentlemen, good afternoon. My name's Julian Leeser and I'm Executive Director of the Menzies Research Centre, and it's my great pleasure to welcome you here to the Adelaide launch of Don't Leave Us with the Bill, the case against an Australian Bill of Rights. I'd like to acknowledge Senator Nick Minchin, Senator Simon Birmingham, Robert Lawson, Vicky Chapman, who actually was an original director of the Menzies Research Centre when it was established back in 1994-1995, Dennis Hood and Roger Goldsworthy, and any other members of Parliament that I may have missed out on. Thank you, and thank everyone for being here today for this very important launch. This book was originally launched by General Peter Cosgrove in Sydney on the 25th of May this year, and today's launch in Adelaide is our penultimate launch. I can announce today that our final launch will be held later this year in Melbourne, which is possibly the home of Human Rights Act activism, and the former Governor of Victoria, Sir James Gobbo, has agreed to launch the book there. I think one of the great advantages of this book is that it's flushed out a number of distinguished Australians who are prepared very strongly to make the case against the Bill of Rights. Some of the speakers that you'll hear from today are our authors, and I think the particular group of speakers that we'll hear from today are people who've had a long history on this debate. In fact, they could be considered almost the lone voices in the Bill of Rights debate up until the publication of our book. And one of the reasons we thought of publishing this book was that we needed to give them a hand, and we needed to give the cause a hand, more importantly. I think those of us who love Australia and respect its traditions often are disadvantaged because we're not prepared to make the strong intellectual case and to make that strong case early and to organise a group of people to back that case. And that's what we've done here with the Bill of Rights book. There are a range of different reasons to oppose the Bill of Rights, and you'll hear some of those from our speakers today. As you're probably aware, the government has appointed a committee under Frank Brennan, the Jesuit priest. I think Paul Keating was unkind enough to call him a meddlesome priest. Turbulent. And turbulent, as Ray Evans would say. And they are investigating whether we need a Bill of Rights. This is the fifth inquiry in recent years into this question, and yet the case against the Bill of Rights has never been as strongly made as it has on this occasion that the Commonwealth's made an investigation. As you may or may not be aware, there's a Bill of Rights in the ACT, there's a Bill of Rights in Victoria, but we want to say it should go no further, but there shouldn't be a federal Bill of Rights. And we're involved in mounting a campaign, a strong campaign, both at an intellectual and a political level, to ensure that it doesn't happen. I'm very pleased today that Janet Albrechtson has agreed to launch this book here in Adelaide. Janet grew up in South Australia and was educated here. She's a lawyer with a doctorate in law, and she is perhaps Australia's most incisive columnist. She's long written about the issue of the Bill of Rights, and she, together with Professor James Allen, who's one of our authors who you'll hear from a little later, are probably Australia's two foremost Bill of Rights opponents. And we're particularly honoured to have a great South Australian here to do this launch, and so I'd like you to join with me now in making Janet welcome.
Thank you very much, Julian, for that kind introduction. It is great to be back in Adelaide, the city of my birth. The last time I spoke in this room was more than 20 years ago for my graduation from law school. Alan Anderson said that he spoke at his 21st, and I was trying to remember whether it was my 21st or graduation from law school, but it was graduation from law school, so it's fantastic to be back here. Instead of going on to pursue corporate battles, I somewhat unwittingly ended up, at least for the last 8 years, being involved in what I think is the much more important culture wars and fighting those culture wars. And one of the most important topics, and one of the first topics that I wrote about, as Julian mentioned, was the democratic deficit that I saw in the Bill of Rights. But my lawyer friends at the time, going back 8 years, said to me, well, why on earth would people be interested in a topic like that? They said, this is really an issue for lawyers, they said to me all-knowingly. Well, they were very wrong, because writing in that furnace of the culture wars, I soon discovered two things. And the first thing was that every time I wrote about the Bill of Rights or judicial activism, I was inundated with mail in support of my scepticism of both those things. And these letters and emails were not from people in the legal profession. The second thing I discovered was the extent to which progressive types suffer from arrested development, frozen in some sort of perpetual adolescence, where emotion, I think, trumps reason. And we see sort of mounting evidence, I think, every day of the left's predilection for emotion over reason. Earlier this month, the Sunday Age reported on a demonstration supporting same-sex marriage in Melbourne. Radical women spokeswoman Alison Thorne told the rally that marriage was an oppressive institution designed to condemn women to lives of slavery, but that same-sex couples should nonetheless be equally entitled to it. Here, I say, what more compelling argument can there possibly be in favour of same-sex marriage than the equal right to be oppressed? But there are other attempts, I think, where emotion, the emotional arguments are more sinister. And we saw that last week with the New South Wales Premier Nathan Rees, who described those who were sceptical about climate change science as being akin to Nazi appeasers in the 1930s. Now, these claims do absolutely nothing to advance debate. The aim, of course, is to shut down debate, to shame opponents into agreeing with the left's position, or at the very least, just getting us to shut up. Anyone who disagrees with the left is invariably labelled as cold-hearted and lacking compassion. Those who wrote to me early on in my career as a columnist for The Australian tended to write in very big font, telling me, littering their emails and their letters with words such as bitch, or Nazi, or hope you die. I was told also somewhat belatedly not to reproduce. An email arrived at 2 a.m. calling me a stupid wench. Another charming gentleman told me to go back to the kitchen in very large print. Well, clearly this man did not like my writing, but I fear he'd like my cooking even less. As someone who's been on the receiving end of plenty of left-wing ire over the years, it's a great honour to be launching a book that's drawn the immediate ire of even the more sensible left in Australia. A book that addresses this issue that is so dear to my heart as an unabashed believer in Australian democracy. And I'm talking, of course, about this push that Julian mentioned for a federal Charter of Rights. And I think here again we see the left employing emotion and duplicity as deliberate tactics to win this debate in Australia. And it was not at all surprising to read a recent diatribe aimed at the launch of this book, which Julian would have enjoyed, I'm sure. Because Don't Leave Us with the Bill draws together some of Australia's best minds, those who are able to inject some cool-headed reason into this debate on whether Australia needs a Charter of Rights. Writing for online journal New Matilda, this angry young human rights lawyer, Tanya Kovac, whinged about the Sydney launch of this book. She whinged about the fact that an Australian war hero, prominent Catholic and all-round nice guy, she said, Peter Cosgrove, was the guest speaker. She whinged that extracts of the book had been read out to applause and had appeared in the mainstream press in Australia. The event, she bemoaned, was well-timed and received national airplay. And meanwhile, on her side of the debate, what was happening, she said? There was no broad-based national information campaign. There were no events to attract media attention. There was no centralised pro-rights branding, no campaign slogan, no stickers, no posters. Her demand to her side of the debate was, put out a goddamn badge or something I can wear. The human rights revolution, she said, is just a T-shirt away. Well, Kovac's hissy fit reminds me of William F. Buckley's observation that those on the left claim to be so terribly broad-minded, open to hearing other views, except then they're so shocked and offended when they discover that there are other views. Now, for years I've been writing and speaking about the emotional tricks employed by those who have called for a Human Rights Act in Australia. And I've asked the simple question, why does one side need to resort to such trickery if a Charter of Human Rights so obviously advances our democracy? Remember the so-called independent consultation committees set up in Victoria or the ACT? Well, they were no such thing, of course. They looked more like a legal version, and you'll have to excuse me if some people in this room are either too old or too young to understand this reference, but those consultation committees reminded me of a legal version of the Village People, that 1970s band where the boys all dressed differently. There was a cowboy, there was an Indian, there was a construction worker, but underneath you kind of knew they swung all one way. And I think here we had highly partisan panels stacked with pro-charter supporters where the outcome was clearly predetermined. Why did Victoria choose to call its Charter of Human Rights and Responsibilities, why did it choose to call its Act a Charter of Rights and Responsibilities when there was not a single responsibility listed in the Act? Why did Victorian politicians pretend that the Charter simply enables courts to declare legislation incompatible with human rights, leaving it up to Parliament to decide what to do? This is clearly dishonest because the Charter makes it clear that every single public authority, every single public servant must act in accordance with the human rights set out in that Act, or howsoever they define those human rights in that Act. If only Section 52 of the Trade Practices Act applied to politicians, I say, because the Charter, the claims made by Charter advocates, the deception does not end there. Remember the claim by Hilary Charlesworth that the Charter, that the Human Rights Act was just a modest little law, an ordinary common garden variety piece of legislation, she said. Wrong. Claims that there will be no transfer of power away from people to the judges are just dishonest. And anyone who's followed the progress of the UK Human Rights Act knows that's just not the case. Just ask former British Prime Minister Tony Blair. He soon discovered what he called were increasing battles between the judiciary and Parliament over critical issues such as immigration and detention. Or defer to the British House of Lords, where their most senior judges have admitted that a seemingly innocuous little interpretation clause in the UK Human Rights Act, copied in the Victorian Charter, is, quote, unusual and far-reaching in character. Now, these provisions have allowed a handful of judges in the UK to determine many critical social issues that had previously been left to democratic processes. Judges have decided that the meaning of spouse now includes a homosexual spouse, despite clear parliamentary intent to the opposite. Courts have ruled that a, quote, right to family life allows gypsy families to set up home on land in clear contravention of planning laws, and so it goes on. In other countries, of course, we know that morally charged issues such as gay marriage are being removed from the democratic decision-making forums. And you need only look to the US to remind yourself that this makes for so much greater division. A few years ago, I had the great privilege of spending a couple of hours with US Supreme Court Justice Antonin Scalia. And I sat down and I turned on my tape recorder and had the best 2 hours of my intellectual life listening to him. The first thing he said was that it is a very dangerous time to be introducing a Bill of Rights into Australia. And I was getting terribly excited, thinking this was going to be a great article. I went home and wrote up this article. It's quite a long feature, but of course he then got nervous because he thought he would be seen to be meddling in Australian affairs. But I thought I'd talk about what he said anyway. Hopefully this bit is off the record. Because not only was he endlessly entertaining, you might recall, certainly I'm sure Justice Callinan will recall some of his great dissents. He described one suspect decision of his Supreme Court as akin to some ghoul in a late-night horror movie that repeatedly sits up in its grave and shuffles abroad after being repeatedly killed and buried. I'm sure we can all think of some decisions that we describe in that way. But Justice Scalia really is the Supreme Court's premier intellectual gladiator, I think. And to have someone like him tell us that it's a dangerous time to adopt a Bill of Rights, I found very timely. He said to me that Western societies have become addicted to pretentious statements of principle. That Americans certainly have a long history of august statements of principle, and he pointed to the United States Declaration of Independence. Life, liberty, and the pursuit of happiness. That's wonderful stuff, he said. But it wasn't a law, it was propaganda. It was to get countries of the world to support the revolutionaries. Nobody ever expected the courts to enforce life, liberty, and happiness, and the pursuit of happiness. He said, I don't mind the puffery so long as you don't write it into law. But we've got this crazy practice of putting these grand pronunciamentos, he's a bit of a soprano man, into law. Once you do that, it's up to the court. You invite courts to become philosopher kings. He was, of course, most interesting when he talked about courts getting into the abortion umpiring business and the effect that that has on judicial appointments. And I agree with him completely that if you are going to allow judges to get into that kind of social engineering, then they need to be elected. because if they're going to behave like politicians, they need to be treated like politicians.
Well,
Let me come back to this book. This book is long overdue because for years the pro-Bill of Rights Brigade have had little orchestrated opposition, as Julian said. But now in one book we have a series of powerful arguments explaining both to the layman and the lawyer why a Bill of Rights will undermine our democracy. Thank goodness, I say, to see judges like Chief Justice Paul de Jersey and former High Court judges Ian Callinan and Sir Ninian Stevens and Justice Keith Handley weigh into a debate which has long been dominated by judges only too eager to see their job description upgraded to that of Philosopher King, interpreting a Charter of Rights. And how refreshing to see that there are in fact plenty of academics, politicians and lawyers who are willing to break from the pack and remind us about the perils of a Charter of Rights. The power of this book is in the breadth of its opinion, from former Prime Minister John Howard talking about those fine title deeds to our democracy, to Cardinal Pell and Rabbi John Levy, and the depth of its intellectual rigour, to drilling down into questions such as how a Bill of Rights will affect our Australian Defence Forces, how it will affect policies such as the Northern Territory intervention, and how it will affect business. The most compelling argument, of course, made by many contributors in this book goes to the core of our democracy. The entire raison d'etre for those pushing a Bill of Rights is to shift power away from the people to a small, unelected group of judges with whom they think their views will coincide. Even Father Frank Brennan pointed out that Victoria's Charter of Rights was, he said, a device for the delivery of a soft left sectarian agenda, a device which will be discarded and misconstrued whenever the rights articulated don't comply with that agenda. Now, I have three pieces of advice for those who are sceptical of the Bill of Rights. First, don't underestimate the power of emotion in this debate. Just about every other day, I bump into a lawyer or some professional person saying to me, but how can you possibly be against a Charter of Rights, something that simply sets down human rights? And I think they've fallen for that simplistic trick employed by the human rights industry that no reasonable person can possibly be opposed to a Charter of Rights. Second, don't underestimate the extent of the trickery of those pushing for a Charter of Rights. We only recently learned that there was in fact a deliberate small target strategy employed during the 2006 Victorian human rights consultation. And we can thank that angry young human rights lawyer for revealing that, quote, it was commonly understood within progressive circles that for the Victorian state government to enact a Human Rights Act, it would be necessary for human rights activists to maintain a low profile. Activists were persuaded by bureaucrats and senior members of the ALP not to use the media or to engage in on-the-ground community advocacy for fear of stirring up anti-rights forces. And that deliberate policy to adopt a hush-hush strategy, of course, worked, because Tanya Kovac admitted that the Charter of Human Rights and Responsibilities in Victoria had been stealthily shepherded through Parliament by Attorney General Holmes. Now, when a piece of legislation that so fundamentally changes our democracy has to be stealthily shepherded through Parliament, you know that those advocating a Human Rights Act have something to hide. But Kovac's plea, of course, for a T-shirt revolution is, I think, even more deceptive, because she wants to win people over with emotion and not reason. But the suggestion that the public should be in support of a charter on the basis of some sexy slogan, I think, does great disrespect to the Australian populace. And as I've written, let's be clear, we're not talking about some campus campaign to save the whales here. The introduction of a Human Rights Act will alter the carefully calibrated balance between our Parliament and our judiciary. Well, it's important not to underestimate the power of emotion and the extent of the trickery in this debate. My third piece of advice is not to succumb to it. And that is why this book is so important, and it's such a credit to Julian and to Ryan that it's been put together. It's the first compilation of essays that addresses in detail how a Human Rights Act will affect our democracy, undermine our democracy. And not only is it pitched perfectly at the rational end of this debate, but it is, as Kovac lamented, perfectly timed. Father Frank Brennan's report on whether Australia should adopt a Human Rights Act is due out, I think, at the end of next month. And I hope this book, which I now formally launch, is mandatory reading for not only panel members and not only every Australian who is interested in our democracy, but also for members of the left, because we know that cool-headed analysis just drives them crazy.
Thank you, Janet. That was easily the most entertaining of the launch speeches that we've had around the country for this book. I am, however, disturbed by one thing. I realise that Janet and Julian Burnside are on a unity ticket on a particular point, and this is the application of Section 52 of the Trade Practices Act to politicians. If Janet and Julian ever form a unity ticket, you know politicians have to watch out. So thank you very much. But it was a terrific launch, and thank you very much for your kind comments. What I'd like to do now is to hand over to some of the authors of the book so you can hear from them directly about their chapters. And as Janet mentioned, I think one of the things that makes this book different from books that have been written by Bill of Rights proponents is the real practical experience that a number of the authors bring. We've tried to find people who had experience at the top of government, at the top of the judiciary, and at the top of the defence forces to be involved in our book. Our next speaker was kind enough some years ago to give me a job, but he is a very, very distinguished lawyer, and he was a former High Court judge, and he's been a long opponent of a Bill of Rights. And I'd like you to make welcome former Justice Ian Callinan.
Good afternoon. Most of the points that I wanted to make have already been made in the essays in the book. But there is one point that I would like to make that I omitted, and I regret that I did in my own contribution. And it relates to the likely impact upon the courts of Australia, upon the workload of the courts of Australia, if Bills of Rights become entrenched, or indeed even if they're enacted. It's no secret among those who have practiced law that there are many former judges, current lawyers, ambitious to be judges, and judges actually sitting, who very much envy the Supreme Court of the United States. They envy the fact that those judges are often in the public eye, that they are, as Justice Scalia observed to Janet, would-be philosopher kings. We have a huge number of judges of that kind in this country, and lawyers. And given the opportunity to decide those cases in preference to deciding other cases, they would seize upon it. And indeed there'd be immense pressure upon them by various interest groups to do that. The High Court currently hears something like about 700, 800 applications for special leave, that is, for permission to have their cases heard as final appeals by the High Court. In the nature of things, the High Court can only do, constituted as it is by 7 judges, can only do about 70 cases a year. And that's rather a lot, I can tell you, because by the time you read the applications and deal with them, some of them have oral hearings, and then you write, each judge writes, say, 40 to 60 perhaps assignments a year. There isn't room or time to do anything else. Faced with the choice of doing that, I think, essential legal work, or being on centre stage in a political sort of a cauldron, there are many judges who prefer the latter. And the practical consequence of that would be that there wouldn't be time for the judges to do what I think is the work they should be doing. The essential work in this country, which has helped to bind the country together, to give commonality of the common law in this country, and to give democratic effect to the various different legislatures and legislation in the country. They just wouldn't do it. The US Supreme Court spends almost all of its time on rights issues, and what it would mean is that for people in ordinary litigation, including important criminal litigation, they'd probably only have one appeal, and the opportunity of only one appeal. Perhaps the states might try to mend that, as they have in the United States, by instituting 2 appeals and having 2 sets of appeal courts in various states. But I don't think that's nearly as good a solution as the one that we've adopted in our Constitution. So that is a serious practical consequence that I think we should have regard to. Could I touch upon two other matters which I think perhaps are only of some indirect relevance but are nonetheless important to a Bill of Rights? And the first is privacy. It's interesting now that, to my knowledge, 2 law reform commissions have recommended that parliaments introduce legislation to prevent invasions of privacy. How ironic it is that most of the opponents of that legislation are people who are in support of the Bill of Rights. I think we ought to bear that in mind. People tend to want what they think is convenient or of interest to them, rather than the contrary. You can't pick up a newspaper today in which you will not find some journalist saying how dreadful it will be and how restrictive it will be if we have to respect people's privacy. The only other matter which I would mention is that I haven't seen any suggestion that a Bill of Rights would protect, as it should do, property rights. And I might say that I think that property rights are under greater threat in this country now than they ever have been. I think that, for example, emissions trading will be more prescriptive and more oppressive than the national security regulations during the Second World War. I think people will now be told what they can do in their factories, in their houses, on the roads, in their travels, and indeed in respect of everything they do. And I don't see anybody who's advocating a Bill of Rights suggesting any measures to deal with that. So I think we have to be particularly vigilant at this time, not only to oppose a Bill of Rights, but also, more importantly, in a sense, and I hope that the opponents of the Bill of Rights take this up, to oppose what I see as the likelihood of most restrictive and oppressive measures designed to give as much central control to this country, control of this country, as politicians can obtain. Thank you.
Thank you, Judge. There's been some mention today of the Victorian Charter of Rights. And I noticed there are a number of people who are here visiting from Victoria, but for those from South Australia and like me from New South Wales, you might not be familiar with the Victorian Attorney General, Rob Hulls. I often say if you ever wanted to imagine what it would have been like to have Mark Latham as the Prime Minister of Australia, you only need to look at the Victorian Attorney General, Rob Hulls, because he is a Lathamite Maddie, essentially, and he's engaged in a long march through the legal institutions of Victoria. When he introduced his Charter of Rights, one of the few people who actually made a submission to that committee against the Charter of Rights is our next speaker, Alan Anderson. That submission that he made was one of the first things I read by Alan, and it was published in the Centre for Independent Studies journal Policy, and it was a pithy and very hard-hitting submission. And Alan obviously takes his advocacy of a Bill of Rights quite seriously, or advocacy against a Bill of Rights quite seriously, because he's been injured arguing with a human rights lawyer. He tells me you should see what the human rights lawyer looks like. Let me now invite Alan Anderson to come and address.
Thank you, Julian. As Janet suggested, the previous time that I spoke in this room was my 21st birthday. So in fact, it's not the first time that I've been legless in this room. It's a great pleasure to be here today, back in my old hometown. And I'd like to thank Julian and the Menzies Research Centre for enabling this book and these events to take place. To a man with a hammer, every problem looks like a nail. To a human rights lawyer, every issue looks like a human rights issue. Now, in The Road to Serfdom, Hayek actually warned against the dangers of entrusting public policy to committees of experts, and he felt that they would be inclined to overestimate the importance of their own area of professional expertise. In fact, Hayek's own profession, economics, is perhaps the most guilty of this. Communism, the ideology that has led to more deaths than any other, was predicated upon the conceit that economists sitting in some central committee would be able to allocate the resources of society more efficiently than individuals operating in a market economy. They therefore felt that these specialists, these economists on the central committee, should be empowered to confiscate those resources and allocate them accordingly. These days we call it a stimulus. Human rights lawyers suffer from a similar conceit. The contemporary human rights movement is an attempt to override the values of the community with the values of a legal elite. Their dream, a charter of rights, would set up a system in which unelected judges, members of that legal elite, act not as judges of cases, as they do today, but rather as judges of the law itself. In a democracy, government occurs with the consent of the governed, the Australian people. They are the final arbiters of the moral content of our laws. They express their views on the subject, largely, but not entirely, through their choice of representatives. Now, Charter of Rights advocates believe that the people cannot be trusted. Their argument is that the people, left to their own devices, will persecute minorities and trample on minority rights. Accordingly, we need a compassionate judicial elite to save us from the whims of the masses. They believe that we can achieve this by enacting a charter which sets out some vague and ambiguous rights like the right to liberty, the right to security, the right to family life, to borrow a few from the Victorian Charter, and then empower the judges to rule on whether specific laws violate those rights. Interestingly, as Justice Callinan recognised, the right to property is nowhere to be seen, and I must say I find that very disappointing. I have a few conservative lawyer friends, and it's one of my long-standing dreams to see them in years to come as eminent jurists striking down taxation above 30% as confiscatory and therefore a breach of the right to property. While the current models in Australia do not permit a court to strike down the law, they do require the court to interpret it consistently with the Charter, wherever possible. And it has been held in the House of Lords in the United Kingdom that this wording may include circumstances where the consistent interpretation is contrary to the interpretation which is plain from the meaning of the words. Now, of course, as these rights conflict, most obviously the right to liberty and the right to security, it means that policy in areas such as anti-terrorism laws and criminal sentencing will be thrown over entirely to the discretion of the judge in that case. But as Lord Acton warned, power tends to corrupt, and absolute power corrupts absolutely. There is no reason to think that the rule of a benevolent judicial elite, empowered by a Charter of Rights to pass judgment on the laws of its country and implicitly on its own people, will long resist the temptation to treat this newly malleable law as a vehicle to enforce its own will and its own values on society. In doing so, they will no doubt fall victim to the very trap that Hayek alluded to. Judges are ill-placed to make decisions on issues of public policy. They are not equipped with the resources of the executive to enable them to weigh competing policy interests or indeed even to identify them. They are not lobbied by affected groups. They are not accountable to affected groups. Rather, they make their decisions after hearing from the parties in issues of dispute, and they make their decisions in the context of legal proceedings and on the basis of legal doctrine. They are lawyers, and to lawyers, legal doctrine comes first. I'm reminded of the debate over double jeopardy laws in New South Wales, and without expressing any view on the merits of that subject matter, one thing which really struck me about that debate was when I engaged in debate with friends of mine from the legal profession. And at the time, I was not a lawyer, I was in fact an engineer. And so, approaching the problem as an engineer, I asked myself the question, if a person had been acquitted of a terrible crime and evidence had emerged subsequently, which made it obvious and plain that they were guilty of that crime, should they not be subject to a new trial so that they might be convicted? There's room for argument on that topic, but what amazed me was in talking to my lawyer friends how they thought that there was none. Their argument was that we could not overturn the doctrine of double jeopardy because to do so would be to breach the doctrine of double jeopardy. This seemed in itself an argument to lawyers, because lawyers base their opinions on legal doctrine. We had another example yesterday. Professor James Anaya, the United Nations Special Rapporteur on Human Rights, condescended to pass judgment on the laws of Australia. Having spent 11 days investigating a problem which we've been confronting for decades, the professor informed us that we must overturn the Northern Territory intervention. This is because it runs contrary to our international law obligations in relation to human rights, in that it detracts from Indigenous Australians' right to self-determination. Community-wide bans on alcohol and pornography were particularly concerning to Professor Anaya, given their discriminatory application. Accordingly, it seems, although he did not explicitly say so, that we're meant to put them back into these communities that were riven by violence, substance abuse, and sexual assaults on adults and infants alike. Now, to the non-lawyer, Professor Anaya's argument must seem just a little bit perplexing. When medical tests show rampant STDs amongst Aboriginal children in these communities, implying appalling levels of child sexual abuse, I suspect many non-lawyers would deprioritise Clause 4, subsection 5, paragraph 2 of the International Convention on Civil and Political Rights and focus on stopping the rapes. Fortunately, we have enlightened human rights advocates like Professor Anaya to educate us in the error of this approach. If we introduce a Charter of Rights, we can have the privilege of Professor Anaya and his ilk interpreting our laws for us, consistent with their understanding of human rights principles. Now, it may be true that the people of Australia sometimes get it wrong, but I hope you'll forgive me if I trust them more than members of an out-of-touch legal elite lobbying shamelessly through its professional bodies for the introduction of a charter which would empower them to abandon their role as servants of the law and take on the role of masters of the law. It would be government of the lawyers, by the lawyers and for the lawyers, and let us hope it is not this country's fate. Of course, in the long term it will not be this country's fate. Janet alluded to the difficulty of confronting people who are arguing for a charter which contains fairly incontrovertible rights, and indeed it would be politically challenging. As a political advisor, or former political advisor, I can tell you it's a great deal easier to attack the judges. Now, there's been an unspoken convention, sometimes an overt convention in Australian politics, that to a large extent we don't do this. Certainly the appointment of judges has not been a topic of controversy in Australian politics. But imagine an environment in which judges were ruling on contentious social issues. Imagine an environment in which, and here the political advisor in me comes out, imagine an environment in which a dangerous pedophile was allowed back onto the streets by a judge, a left-wing judge appointed by a Labor government. Surely there would be a temptation in this environment to wax lyrical on the merits or otherwise of the appointments process engaged in by the current government. The moment that the judiciary becomes politicised, they will be subjected, and indeed the appointments process will be subjected, to a level of politicisation, and it may well be tabloid politicisation, that we have not experienced in this country. And this is not just a hypothesis of mine. This is, of course, based on strong evidence from the United States, where prospective judicial nominees are subjected to attack ads. That's not just the people appointing them, the prospective judges themselves. Australian democracy is very robust, and I am convinced that regardless of the outcome of this current debate, it will survive and the will of the people will be reasserted, even if it is briefly taken away, once they realise that their right to govern themselves has been so constrained. The only question, to my mind, is how much damage is done to the Australian Constitution through this process.
Thank you, Alan. Now, our final speaker for today's launch, and really what we've done is bookend today's launch with the two most prominent advocates of the case against the Bill of Rights, Janet Albrechtson, who's probably the most prominent public advocate, and Professor James Allen, who's probably the most prominent academic advocate of the case against the Bill of Rights. Professor Allen is, if you like, a refugee from human rights acts all around the world. He's lived in Canada, they now have a Human Rights Act. He's lived in New Zealand, they now have a Human Rights Act. He's lived in Hong Kong and in Britain, they've also got Human Rights Acts. I hope that there's a pleasant Caribbean island somewhere that doesn't have a Human Rights Act if the Brennan Committee decides to recommend one. He's a very engaging, entertaining and academically rigorous speaker. Ladies and gentlemen, Professor Janet Albrechtson.
I'd like to thank Julian for that introduction, but those are the worst sorts of introductions. Well, I do have a contrarian bone or two in my body, which is a good thing, because when you work in a law school the way I do, I can tell you an American colleague of mine did a study in the US. He took all the tax receipts of people who donated money in the top 20 American law schools, where you can actually look to see if they donate it to the Democrats or the Republicans, and the figures are astounding. This is not, where I work is not an environment where you find virtually anyone who would vote coalition. So actually that's something of an advantage, because I get to hear every day all of the arguments for, and I probably work in the most conservative law school in Australia, but that means maybe 15% would vote coalition. But you do get to hear the other side of the argument all the time, and these are, I mean, very nice, intelligent people, and you get to actually think about their side of the argument. There are whole law schools in Australia where they would not hear where the pro-Bill of Rights side of the argument would ever hear the other side of the argument. Just would never come up, and I'm not exaggerating. So let's just start. The other thing I thought I'd say to start is this book has been a delight to be part of, because part of being a contrarian is that, I mean, I get a little bit of hate mail, probably not as much as Janet, but you get the hate mail and it just sort of bounces off you. They call you all sorts of names, or blogs calling you names. But sometimes what's worse is to get an email that agrees with you. And as you're reading the email that agrees with you, that's just so off the wall, you're going, oh. And this book was delightful, because here were people that agreed with me that I liked reading, as opposed to sometimes the emails you get where you think, oh, I said to my wife, oh, I've got to change my mind, I can't read this anymore. Here's some of the things that are going to happen when the Consultation Committee delivers its report. You have to remember that the Attorney General was on the record beforehand being in favor of a statutory Bill of Rights. He appointed Father Frank, who at least in 4 or 5 written things was on the record being in favor of a Bill of Rights. Nobody in the Consultation Committee is known to be against the Bill of Rights. It would be exactly the same as appointing me and the 4 or 5 living skeptics to a Bill of Rights to be the only people on the committee, and then have the committee come back. Now, these are all sincere, honest, nice people, but you'd have to be a very brave person to bet against them recommending a statutory Bill of Rights, since they've all were on the record beforehand saying that's what they thought. Now, you will hear that they've talked to or spoken to, I don't know, what is it, 40,000 Australians? You know, we've had submissions from 40,000 people. It sounds great. Here's another way of putting it. We've spoken to 0.2% of the Australian population, and on the basis of that, we feel pretty confident to make a whole bunch of conclusions that no one could disagree with. Most of the people in favor of Bill of Rights started off in this country favoring a constitutionalized Bill of Rights, put in the Constitution. The trouble with that is, Australia has a delightful constitutional amendment procedure where you actually have to ask people. You don't have to actually do that in Canada or the US, but here you have to have a referendum. And when they do that, they lose. So here's a neat thing. We'll have a statutory Bill of Rights, because statutory Bill of Rights, you don't have to ask anybody. Well, politicians can just put one in. Now, I know that George Williams of the world say, oh, well, actually, I've had a Damascene conversion. I used to be in favor of a constitutional Bill of Rights, but now I recognize the great merits in allowing parliaments to think about these things. I've decided the statutory Bill of Rights is better. It's also, as it happens, a lot easier to bring into force. Well, you've already heard how they work. Statutory Bills of Rights, on the face of things, if you don't think about them at all, seem to leave the last word with Parliament. Statute, Parliament can repeal the statute, although there is no jurisdiction anywhere in the democratic world where any government has ever repealed one. And I would bet that the coalition here would not have the nerve to repeal it either. Haven't repealed it anywhere else. They're talking about it in the UK, but I don't think they will there either. In fact, Cameron's completely incoherent on the point. But leaving that aside, if we get one, unlike Alan, I bet a lot of money that we won't, that the coalition gets back in someday. They won't do anything about it, which is depressing. But here's how they work. They leave this sort of patina of Parliament has the last word, but they have these 2 provisions that are incredibly strong. One's a reading down provision, you've heard about it. It just says to the judges, do everything you can to interpret all other statutes as consistent with the enumerated rights in the Bill of Rights. As if those rights are self-evident how they play out. What they really mean is interpret it in the way you think these rights ought to play. And that really doesn't tell you anything. The phrase is usually, as far as it is possible to, or if you can. And nobody knows how far they can go, but in the UK they've basically said we can read words in, read words out, ignore the clear intention of Parliament, we don't need any ambiguity, we're just going to pretend we're Alice. And a word means whatever I want it to mean, and they have done that. It's not, that's basically a quote. So I always say, well, imagine you're in a marriage, right, and both you and your spouse want to be the sort of top dog. You want to have the power. Now, who would you rather be? Would you rather be the spouse? Would you rather be the I'm not going to say partner, I still can't get the hang of that. Would you rather be the husband or wife who let's say the husband gets to write down everything you're going to do in the marriage. So, I get to write down and we have to do it. The husband gets to write down whether the kids are going to go to a Catholic or a Protestant school, who's going to come to the house, who your kids can marry. Imagine the husband writes it all down. And then the wife, all she gets are the little leftover powers from a statutory Bill of Rights. She gets to interpret the rights, or she gets to interpret everything the husband said. But she gets to interpret it in this new way that no one's ever interpreted before. You don't actually read the words the way they were intended to put, in the light of what they're intended to mean. You read them in the light of what the wife thinks are her own personal, timeless, eternal rights. So when she reads it and she says, well, I understand that you want our children to be able to marry only heterosexually, but when I read that, I understand that in the light of timeless fundamental rights, so I'm going to actually read that the exact opposite way. And she can do this as much as she wants, but if that doesn't work, if she finally reaches a point where she said, this is not interpretation, this is just making it up, and who knows how far, she might even go as far as the British judges, which is way over there, she can also issue a declaration, and these declarations are like moral blackmail. What they do is they say, you politicians have taken away citizens' timeless fundamental rights. But of course, if you want to do that, go ahead. Now, in 27 years in Canada, because they have a similar provision, the federal parliament in Canada has never once stood up to the judges. Well, in theory they can, but they never do. Even when the Canadian judges struck down health and safety legislation that stopped billboards outside of schools advertising tobacco because that's a breach of free speech for tobacco companies, the politicians backed down. Don't want to be seen to be taking away rights. Look, it's a fundamental mischaracterization about what the disagreement is. The politicians aren't disagreeing with the judges in the sense that they want to take people's rights away. They have a different view of how rights ought to be understood. It's not a breach of a proper understanding of the right to free speech to say you can put warnings on beer bottles to tell pregnant women they ought to think twice before they drink. It's just a different understanding of rights, but they don't get that. On a statutory Bill of Rights, the judges will be telling us what our rights are. All that's left to the judges, the politicians, is to say, oh, okay, we'll take them away. So in this marriage, would you rather be the husband or the wife? And I say it's pretty obvious. What else? Just on the judicial appointments. So anyway, just on the consultation committee, I'm pretty sure that some sort of recommendation will come back giving us something people in this room aren't going to be too happy with. And I personally am pessimistic enough about this to think that the coalition's not going to be the ones that block it. It's going to be the Bob Cars, the sort of old-fashioned redistribution of wealth side of the Labour Party. And they are the ones who are actually also doing a very good job right now because the Chardonnay drinking side of the Labour Party is all for this. And if they thought they could get it through their own party, which is what happened in New Zealand, what happened in the UK, it would happen. Now, of course, we have a functioning upper house unlike other places, so it's not clear whether it'll get through the Senate. One can only hope not. But if we do get one, then unlike Alan, I would be very pessimistic of it ever being repealed. It's opposition parties just lose their nerve, or so far they have. Last thing, judicial appointments. Well, Australia is one of the few places in the world that could actually move to an American appointments process. Because in order for that to work, you actually need to have an upper house, like a Senate, that's actually elected. So that rules out Canada, that rules out the UK. New Zealand doesn't have an upper house. You can't actually have your vetting done by the lower house, because by definition the government controls that. So we could actually move to an American-type system, and indeed our system would probably be even more vigorous because it's much harder to control the upper house here than it is in Canada. Than in the US. That won't happen, I'm pretty sure. But even worse than the status quo, and I think of the status quo as the Westminster system where the executive appoints the judges, even worse than that is this faux independent appointments committees that they've got in the UK, they're moving in here. This is judges picking their own replacements. And that is the worst appointments process on the planet. And it's sold under the guise of being, well, it'll just be independent. Can you imagine, you could think of the sort of outlying judges who've done a great job, Scalia's, Posner's, people in Australia, I won't mention any names. They will never get appointed under an appointments committee. It'll be the sort of middle status quo.
And the Masons and the Brennans.
Well, even, yeah, I mean, what you're going to get is the median outlook of judges being appointed. So I think judicial appointments, the minute you get a Bill of Rights, become a very hot topic, and in a way it can make things worse. But let me say again what a delight it's been to be part of that book, and I want to thank Julian for having invited me, and thank you all for coming today.
Thanks very much, Jim. Well, just to wrap up, if you haven't bought a book, you should buy one. They're $30 each. If you've already bought one, remember Father's Day is coming, only a couple of weeks away. They make fantastic gifts. Finally, Janet mentioned the importance of slogans, and I think there are two slogans for those of us on the anti-Bill of Rights side of the debate that we should take away with us. The first one is the idea of no vote, no bill. If we can have a vote on something like whether Advance Australia Fair should be our national anthem back in the 1970s, then surely we Australians, ordinary Australian people, not the parliamentarians, deserve a vote on whether we're going to have something that alters our system of government as much as a Bill of Rights. The second slogan is a slogan you'll find in the book. It's a slogan that was used back in 1988 when Australians rejected putting a Bill of Rights into the Constitution by 70% to 30%. And that was a slogan that said, there's more to this than meets the eye. And I think as you've heard from all of our speakers today, that's very, very clear. If you're going home and you want to tell friends and family that this is a bad idea, you might want to tell them that there are 3 good reasons to oppose a Bill of Rights. The first is that a Bill of Rights is expressed in unclear language. We have no idea what exactly the freedom of expression or the right to a family life really means. Secondly, as we've heard from our speakers, it has a range of unintended consequences, things that couldn't have been predicted, as Jim Molan in our book says about the application of the Bill of Rights to the British Defence Force, which no one expected. And thirdly, it transfers power to unelected judges, and therefore really distorts our whole political system. Ladies and gentlemen, thank you so much for coming today. Can I also thank Ben Davies, who's a friend of mine who has been very kind in coming here to sell the book today. He was also very kind in having a look at my own chapter in the book and making some very constructive comments. Please buy a book, please buy 2, please buy 5, and have a safe journey home.